will determine the level of abortion access in Kentucky have begun in Frankfort. The Supreme Court waited until after the election to hear the arguments, wanting to see how the state would vote on Amendment 2, which would declare abortions unconstitutional. However, with the amendment now being rejected by close to 100,000 votes, arguments are now taking place. Isaiah Kim Martinez is in Frankfort listening to those arguments. Isaiah, you've been in the courtroom all morning long, and this has been a major issue, as you well know, in the Commonwealth for quite a while. What can you tell us about what's been going on inside the courtroom?
Well, Eric, you mentioned it. That urgency was felt here inside the courtroom right behind me. The Supreme Court's first order of business here is to decide whether to reinstate that temporary injunction, which, if they decide to, would again make abortions legal again within the state of Kentucky. That's at least as the case is litigated through. This is, of course, what the ACLU of Kentucky has been pushing for on the grounds of a right to privacy guaranteed in the Constitution and a right to self-determination, which they say directly applies to abortion, especially given right now where they say women are suffering irreparable harm due to Kentucky's trigger law, while the other side, the general counsel for the Attorney General's office, again doubling down on the fact that they believe this is an issue for the General Assembly, for legislators to decide, and if Kentuckians want different, to reflect that in their vote. Speaking of that vote, let me go ahead and reference the video you either just saw or are seeing now as far as Amendment 2 goes. Eric mentioned it. We saw protesters here today with signs saying, "We voted no." Our voices were heard, in their words, and the justices wasted no time in bringing up Amendment 2, even for a moment questioning whether the Attorney General's office was ignoring the vote, where the majority of Kentuckians did in fact vote Amendment 2 down. They also questioned whether it's appropriate to reference the Constitution more than 100 years back, before women even played a part in writing that. That was for the general counsel for the AG's office. Meanwhile, back over to the ACLU of Kentucky, they asked about whether doctors can play a role as a third party on behalf of their patients, and when self-determination ends, at what point do they then feel like abortions should be in play, whether that be the 15-week point, the 20-week point. I do want to mention right now, this is why this is very, very important for viewers to realize here, the 15-week ban in Kentucky is still in place. Both sides admit, regardless of what happens here, 15 weeks will be that barrier point. We'll discuss that a little more in our early evening shows. For now, I'm live here at the Capitol. Isaiah Kim Martinez, WHAS 11 on your side.